Welcome everyone. Thanks a lot for staying with us. You're watching Plain Speak with me, Shivani Gupta. In what can be seen as a setback to Delhi Chief Minister Arvind Kejriwal, he has been asked to appear before Delhi's Rouse Avenue Court on February 17 on ED's complaint over non-compliance of summons in the excise policy case. Kejriwal has skipped 5 summons so far, remember. His party men Sanjay Singh and Manish Sisodia are in custody over the same case for many months. Now, the Aam Aadmi Party has reacted by saying that they are studying the order and they will take action as per law. They added that they will inform the court how all ED summons were illegal. This is what the CM has been saying in response to the summons publicly. It is crunch time now for the party. Will the political vendetta or witch hunt argument or the summons being illegal argument hold water in court or not? In fact, what happens in this case could well have repercussions on many other cases, especially ones involving opposition leaders ahead of elections. Many of them have been making the political vendetta argument publicly over raids or cases against them. Already, the Supreme Court has upheld ED's powers regarding arrest, search, attachment and seizure in money laundering offences, the validity of the PMLA Act, and even upholding the reversal of the burden of proof under the PMLA. The Supreme Court has also remarked in the past that there cannot be separate guidelines for politicians in such cases. If court also validates ED's power to summon without providing any breakdown of reasons, as Arvind Kejriwal has asked for, it could put paid on opposition's campaign against central agencies. The big question today, though, is this: will Arvind Kejriwal now comply? We take that to our guests in just a bit. First, let me just break down what the ED pleaded before court. The agency has actually not pulled any punches against Kejriwal's refusal to appear in this case. So the ED plea said that the accused is a high-ranking public functionary. They're using the word accused here, although Arvind Kejriwal is not an accused so far in the liquor case. But in this complaint, he's the accused. So that is why the term accused comes. They also say the accused respondent is expected to obey the law. If persons holding high offices like him disobey, then it sets a wrong example. The respondent intentionally omitted and failed to appear. Now, this is very key. The agency making the charge on intent. Despite numerous summons, the respondent failed to appear on various dates because, as I mentioned, it's been 5 summons so far. Committed offence by intentionally disobeying public servant's order. This is an offence, mind you, as per Indian Penal Code. Instead of attending summons, Kejriwal raised frivolous objections. This could refer to the fact that Kejriwal has been saying these are illegal summons. They haven't really described to him the grounds on which that they are calling him as a witness or as an accused, in what case, in what role, etc. The ED also had gone on to say that the accused has created grounds that show intentionally did not want to obey summons. So again, they say that the grounds that he has used show that actually the intention was just to not come. The next one is also very interesting because they actually say that these are lame excuses with an intention to make out a false defense. Kejriwal's intention was to disobey the summons, the agency reiterates, and the intent was to create a false pretext to camouflage such intention. The big question we ask today is simply this: will Arvind Kejriwal now comply, given that this is a court order and not really an agency summon? Let's go across to our guests joining us. Anuja Kapoor, spokesperson of the BJP, Vandana Sinha from the Aam Aadmi Party joining us. Satyendra Singh is former Deputy Director, ED. Ashwini Dubey is an advocate in the Supreme Court. I do thank you all for your time. Vandana Sinha, I want to begin with you. Could you update us if the Aam Aadmi Party has decided anything after the court order? We've also accessed a copy of the court order, and the court is very clear that prima facie an offence is made out against Arvind Kejriwal under the Indian Penal Code.
Good evening to everyone. First of all, I want to say the summon which has been issued by the court, we will definitely respond to it. Aam Aadmi Party never disobeyed or never violated any law or rules. So definitely we are going to read the summon which will be received from the court. And as far as the summons has been served to Arvind Kejriwal by ED, as we already said, the summon, because the ED has power to serve the summon under Section 50 PMLA. They served, it was a politically motivated summon, even though every time Arvind Kejriwal has responded to summon and asked under what provision it has been sent, because every summon has a schedule. The schedule was not properly mentioned in the summon which has been served. There was nothing in the annexures as well, no questionnaires. Every summons we have responded and asking the ED under what investigations they have called us, because if the schedule has all the information about the offence, whether the ED is calling calling Arvind Kejriwal as a witness, as an accused, or what the document he has to bring, but nothing has been mentioned. It was contrary to the law. It was deliberately said.
Yeah, but ma'am, the court will, ma'am,
BJP.
Vandana Sinha, with due respect, the court will decide that now. I know that is your argument, but you have to present yourself in front of the court. You can't sit in judgment. This is precisely the problem with the stand that Arvind Kejriwal or the Aam Aadmi Party had taken. You can't declare a summons illegal. And many people had asked the question, why doesn't Arvind Kejriwal go to court to question these summons? Now the ED has done that. You could argue the ED has duly taken Arvind Kejriwal to court, which is what the Aam Aadmi Party should have done if you had a problem with the summons.
Now, if we have received the summon from the court, we will definitely reply it. We never disobeyed any order of the court. We will see what is the order which has been passed by any other court, and definitely we will challenge the summon.
Of course you will comply unless you decide you don't want to. So that's not really, a wonderful argument to make. Of course you will comply. That's not my question. My question is, first, if you had decided anything, I think your team said last we heard from them that you will look at it and proceed accordingly. But on the argument of illegality of these summons, can I just read out what we have managed to access of the order today by the court summoning Arvind Kejriwal on February 17th next? Prima facie case of disobeying summons is made out against Arvind Kejriwal. Prima facie offence under Section 174 of the Indian Penal Code 1860 made out. There are sufficient grounds for proceeding under Section 204 of the Code of Criminal Procedure 1973 against Arvind Kejriwal. Is that, according to the BJP, an indictment of Mr. Kejriwal? You feel that you've been vindicated in this case? Anuja. Anuja, this is for Anuja. Because this order prima facie establishes ED's case, and ED has made very strong arguments which I'm running on screen, what they pleaded in court.
Jai Shri Ram, good evening to you and to my panelists and to the viewers. So now there is an interesting catch which is going on. A Lok Nayak, Khal Nayak, now become a lawyer and now playing a victimhood card. This is very good, and he's done it in an excellent way, in a melodramatic way. He's always done it. The person who believed that there should be a Lokayuk in the states now is talking and evading the ED summons. The person who believed that the resignation should be first and then the investigation should follow is the one who's sitting on his seat shamelessly and trying to become an absconder and running in the states on the name of the elections. ED has not only talked about the charge sheet. The ED has already talked about the charge sheet long way back, in which they have said that in the court during when they had an assistant Kejriwal questioning will be coming soon, when they grilled the personal assistant Bhevav Kumar. He is the Dialogue and Development Commissioner, Vice Chairman of Jasmine Shah. So at that time, Kejriwal was already been asked, and they have talked about it in the court, that they will bring Kejriwal in the court. And the court had talked about that the AAP should be a part of the party in this case. Now, Arvind Kejriwal, as a Chief Minister of Delhi and as a conveyor of Aam Aadmi Party, and under whose guidance the liquor scam happened, so he is the one who has to answer and question
Again,
we see this as a fiduciary relationship, and we see that in a principal and agent also, when we have a fiduciary relationship under this.
Again, the court will ultimately decide if there is that responsibility that the Chief Minister has to fulfill. In some ways, it is good that this has now gone to court, because we've seen a lot of these arguments of political vendetta being made in public discourse.
Why do we have to go to the court?
No, the ED has gone. The ED has gone to court. Just let me finish, Anuja. I think it's a good thing, because a lot of this political witch hunt argument is made. You would notice that actually, legally speaking, none of these arguments are never made in court in any of these cases. Now, it will be very interesting to see what Arvind Kejriwal says in court. Is he going to say that, yes, this was political vendetta against me, the way the ED was summoning me? Is he going to say the summons were illegal because there was this reasoning not meted out to me? On that, I also want to go across to Satyendra ji, who's joining us. He's a former ED official. अरविंद केजरीवाल ने बार बार यही बोला है कि उनको रीजन नहीं बताया जाता, उनको ये नहीं बताया गया कि वो अक्यूज्ड हैं, विटनेस हैं, किस कैपेसिटी में बुलाया जा रहा है, किस सेक्शन के अंडर बुलाया जा रहा है. अभी आपने सुना होगा आम आदमी पार्टी की स्पोक्सपर्सन ने क्या बोला, इसलिए उनके लिए ये समन्स इलीगल थे. अब तो खैर ये कोर्ट डिसाइड करेगा वो क्या आर्ग्यूमेंट रखते हैं कोर्ट के सामने, बट एज एन ईडी ऑफिशियल आप क्या कहेंगे जो उनका तर्क रहा है अभी तक?
शिवानी जी नमस्कार, आपको भी और सभी दर्शकों को भी. देखिए, ये जो तर्क है इसको मैं कुतर्क कहता हूं, ये तर्क नहीं है. ईडी ने जो भी सम्मन किए हैं वो जो सेक्शन 50 में पावर्स हैं उसी के तहत किए गए हैं, और उन पावर्स को माननीय उच्चतम न्यायालय अपहेल्ड कर चुका है. सेक्शन 50 में कहीं ये प्रावधान नहीं है कि ये बताया जाए कि आपसे क्या सवाल पूछे जाएंगे, आप एक्यूज हैं, आप गवाह हैं, ऐसा कोई प्रोविजन है ही नहीं. और
किस केस में बुलाया जा रहा है, किस सेक्शन के अंडर बुलाया जा रहा है, ये बताना पड़ता है.
मैं बताऊं, देखिए सेक्शन तो 50 का सम्मन जाता है, उसमें क्लियर मेंशन है कि अंडर द सेक्शन 50 आपको कॉल किया गया है. इसके अलावा कुछ डॉक्यूमेंट जो ईडी को यदि जरूरत होती है तो वो शेड्यूल में लिखा जाता है. लेकिन ये कहना कि साहब हमें आप एक्यूज के हैसियत से बुला रहे हैं, गवाह के हैसियत से बुला रहे हैं, या हमसे क्या सवाल पूछे जाएंगे, तो क्या ये इन्वेस्टिगेशन इनको पहले से बता दिया जाए कि क्या इन्वेस्टिगेट होने जा रहा है, क्या सबूत एजेंसी के पास हैं? तो ऐसा कोई प्रावधान एक्ट में नहीं है. और ये देखिए, देश में जो भी कानून है हमारे यहाँ, उनमें कहीं भी ये नहीं लिखा हुआ कि आम आदमी के लिए कानून अलग होगा, उसके प्रावधान
और पॉलिटिशियंस के लिए अलग होगा. नहीं, ये बात तो सुप्रीम कोर्ट कह चुका है. बहुत सारे ऑपोजिशन लीडर्स गए थे आर्बिट्रेरी केसेस का एलिगेशन लेके सुप्रीम कोर्ट के पास. सुप्रीम कोर्ट ने खुद बोला था कि पॉलिटिशियंस के लिए कोई अन्य मापदंड थोड़ी ना होंगे, जो रूल है वो रूल है.
जी हाँ, फिर भी देखिए इनको पूरी छूट दी गई कि आप ये डेट्स हैं, आप बताएं कि आपका बयान कहाँ रिकॉर्ड किया जाए, आप जगह बता दें हमें, क्योंकि आम जो आदमी है उसको ये सुविधा नहीं दी जाती. तो इनको सुविधा दी गई है. अब आरोप लगाना अपनी जगह है कि आरोप लगाएं. अब अदालत का सम्मन आ गया है
जी.
मैं जहां तक समझता हूं उसको इलीगल नहीं कह पाएंगे ये पब्लिकली.
Well, that is the thing. Now, politically, one could argue that Arvind Kejriwal has been pushed into a corner, because you can allege whatever you want against an agency, you can call their summons illegal, not attend, but you can't do that against a court. And surely you would now be expected to put on record legally What is your argument for not appearing before the ED so far? The agency could argue that it has been patient. In fact, Ashwini Dubey, I want to come to you. I read out what the plea of the ED was, and it's a pretty strong plea. You know, they've basically said Arvind Kejriwal has been making lame excuses. This was with an intention to just not appear. There were, grounds on which, frivolous grounds on which that he was arguing not coming, don't stand. And I read out what the court order is also saying, that prima facie offence under section 174, section 204 are applicable. And therefore, they've naturally asked the person concerned to appear to present their case. What are the options, if any, available before Arvind Kejriwal now?
Thank you, Shivani, for having me here. Shivani, it's an ongoing investigation where many people are already in jail. And Shivani, when any agency, the law of the land says that when any agency wants any either individual or any authority to investigate during the investigation of a matter to appear before the agency, that person is bound. And being the Chief Minister, having on such a constitutional post, the responsibility is much more than any individual. It's not a first time. For first, second, third, fourth, fifth summons have been issued. And if anyone is aggrieved by the process, then there are courts. One can challenge the summons to the court of law and may get it declared as a null and void, saying that, look, you don't have authority to issue a summons. So far as the powers are concerned, power of any investigator, including the prime investigating agency, Enforcement Directorate, is well versed. That has been upheld by the Honorable Supreme Court in one of the judgment that look in
on the issue of summons, you must have heard what Arvind Kejriwal's argument is. Has this come up before courts in the past? Is there any judgment that the current court could rely on? Because Arvind Kejriwal's argument has been that these are illegal summons. He has questioned the intention plus the due process followed by the ED.
The process is only issue summons and to ask any person to appear and to depose the answers asked by any agency. And so far as the issuing summons and powers of ED are concerned, that has been given in the Act, PMLA Act Section 50, which says that they can issue summons either as an accused or either an witness to ask to depose either as an accused or the witness. So here, if he is avoiding summons, then there are two processes. Either he should challenge the summons, and there is no law which can declare any summon to be invalid unless it has been issued by mistake or unless it has been issued to a third person.
So there is not a certain pattern or a certain format that the summon has to be in. I think that has been what Aam Aadmi Party's contention has been.
The formats are already there. ED, the formats of any, either the police format or the CBI format or ED formats, notice, or the court's format. The formats have been laid down and there is one format only. Only thing is they have to mention that what is the time, what is the date, which is the place. And it is not the first time. This is the fifth time summons have been issued. So very first day he should have gone there instead of crying for the political vendetta. Because you remember, it is a case which is being investigating where under the private individual civil service deputy, opposed the liquor policy. And that too, at that point of time when COVID was there and the policy came into picture, then many people are there languishing in the jail, and courts have still not termed that offence to be based on the political vendetta.
Right.
Relying on the investigation of the
I want to understand from you very quickly, now that the court has issued summons, and I think that the difficulty for Arvind Kejriwal could be, I don't know how he views it, but could be that he's been asked to appear in person. So, are there any options before the Chief Minister to say, okay, I'm not coming in person, but I will send my response to you, or what are the options?
So, he can ask, but see, it's the court order. Not going there, court may issue the warrant. Court may ask the Enforcement Directorate that, look, this person disobeyed my order, and it's a criminal case, so warrant are hereby issued. So warrant, either he should challenge this order before the appellate court. Appellate court may either say that, look, order is bad in law, therefore we are quashing it or we are upholding it. Or if he does not appear on the February 17th, court may ask the Enforcement Directorate to issue the warrants. This is the process. This is which is fall in any criminal jurisprudence, in any criminal law. This is a
So
process.
this is where the difficulty is, Vandana Sinha. You know, both procedurally now, you can't be seen to be dilly-dallying. You have to make yourself available. A court summon is not the same as an agency summon. And secondly, politically also, you cannot be seen as dithering on appearing. Chief Minister, if anyone, has even greater responsibility to uphold the law and to cooperate.
Shivani, as I already said, it's not like that when we have received the summon, we have properly respond to the summon, asking ED to send a proper summon, and the summon which has been issued by the court, it's just a summon. So definitely we are going to respond it. If it is required, Arvind Kejriwal must appear before the court. Secondly, it's a summon which has been issued on the plea, which has been submitted by the ED itself. We also have to explain how the summon was not as per the law, how it was arbitrary, how it was illegal. So the summon which has been issued on the plea, which has been the submission has been made by the ED. Now the court has to hear Arvind Kejriwal too. Then only the court can be come into a conclusion, because this is very early to comment, because summon can be issued on the basis of any allegations made by any party. So definitely the summon has been issued. So we are going to reply it. We will obey the court orders. We never disobeyed the court order.
But
it's a long,
before I go to
long,
Anuja, Vandana ji, wouldn't you accept that this is worse than, let's say, if you believed so strongly that the summons were illegal, you should have gone to court. You should have had the upper hand and gone to court and say these summons are illegal, please quash them against me, or ask the ED to furnish the summons in a better way, in the proper way that we believe hasn't been followed. Now what has happened is the ED has taken the Chief Minister to court.
See, every time, because we followed all the rule, all the law, all the procedure, every time we ask the ED to send a proper summon to us.
Ma'am, can I just say, if you followed every process, every rule, every procedure, the court wouldn't have said that prima facie there is evidence of the fact that you were refusing to appear illegally. This is a criminal case.
No, it's. I mean, like the ED, first ED has to, because how we are going to appear before the ED if ED has not sent a proper schedule which contains all the information, whether we have to appear as an accused, we have to appear as a witness, or we have to, what documents we have to bring. It is the procedure. It is a procedure, and the ED also have to follow everything.
Okay, all agencies keep saying this is not required. I just asked Satyendra ji, I will give him one more opportunity. But Anuja, you want to respond very quickly. Politically, does this strengthen your argument?
I really don't understand what Aam Aadmi Party is trying to create, this mockery of their own party. And I would just say, why would the court will give the ED summons? It is the ED who has to give the summon. It is the job of the agency, of the investigation agency. And what is proper summon? I really don't understand this line of what is the proper summon and how many precedents can you give me right now? Ma'am, please. Ma'am, please be quiet, ma'am. Ma'am, please be quiet.
One by one, please. One by one, please.
What is the proper summon, and how do you get a proper summon, and how many people till now, till date, in so many years, ED has given summon and CBI has given summon to so many. How come Arvind Kejriwal is above that? And there are people who have gone on the investigation. A common man has gone, even a chief minister has gone, and there are people in various areas who have gone and the summons and got into investigated. So why Arvind Kejriwal is such a special darling for all the people? I would like to answer a question on 2nd November, if this was such a big issue for you and you are questioning the ED, what is it, on which basis you try to evade the agencies? Because Supreme Court has said that there is a trial of rupees 338 crore. That is why Sanjay Singh is not out. So you have to talk about that too. And
one by one, one second.
Today's court.
today's court order has nothing to do with the merits of the case. Let's not get into that because, you know, that's another argument. We've had that argument over a period of time. The case is not done. The trial is not done. Let's not pass judgments on what the court will decide in future. The ED has made, the agencies have made their case.
About this.
No, one second. The agency, no, I'm sorry. You cannot present, no, I'm sorry, Anuja, you cannot present it like that. The ED has made its case in court. The court is listening to the ED's case. The trial has not happened. The trial has not happened. Nobody has been indicted and nobody has been convicted.
It is not about the trial also.
No, no.
It is not about the trial also, Shivani.
Even the trail that, even the money trail you're talking, one second ma'am, even the money trail you're talking about is now still subject to a trial. It has to be proved yet.
Subject or there is not, Shivani. The thing is, he has to be present.
That's a separate matter. I'm just saying, don't argue the merits of the case as if the case has been decided.
I am not saying anything. The already Supreme Court has said it is the prima facie. It's a merit in the ED charge. So it's not me who's saying anything. I'm sorry.
Yeah, prima facie is prima facie. That's what I said. It's not a judgment on
that's
it.
What I'm even.
One second.
So that's what even I'm saying.
Yeah, Satyendra ji, very quickly, this schedule thing that Vandana ji is talking about, I think I would be remiss if I don't ask you to clarify. ये schedule चीज क्या है जो वंदना जी बार-बार बोल रही हैं कि हमारे समन्स में नहीं थी, इसलिए हम नहीं आए थे?
जी, देखिए शेड्यूल जो होता है, शेड्यूल में कुछ भी नहीं होता. शेड्यूल में ये होता है कि आप ये डॉक्यूमेंट साथ में लेकर आए. ठीक है. जिसकी जरूरत होती है एजेंसी आईओ समझता है कि मुझे इनकी जरूरत तो और पड़ेगी. जैसे बहुत सिंपल होता है. देखिए जब पहली बार बुलाया जाता है किसी को तो बहुत सिंपल चीजें होती है कि आप अपनी पासपोर्ट डिटेल लाइए, आधार लाइए, आपके कहाँ का बैंक अकाउंट है, आपके फैमिली मेंबर्स कौन कौन है, किस किस कंपनी में आपका बिजनेस इंटरेस्ट है, कहाँ कहाँ आपके लोगों के बैंक अकाउंट है, आपकी आईटीआर की कॉपी लाइए पिछले इतने साल की. ये शेड्यूल में ऐसी चीजें होती हैं. शेड्यूल में कहीं ये नहीं होता कि ये क्वेश्चंस हैं जो कि हम आपसे पूछेंगे तो आप इसकी तैयारी
नहीं. बट अगर ये कह रहे हैं, आम आदमी पार्टी के लोग कह रहे हैं कि हमारे जो समन्स थे उसमें ये शेड्यूल मेंशन नहीं था, तो क्या वो समन इलीगल नहीं हो जाता फिर?
देखिए यदि शेड्यूल में कुछ भी नहीं है तो भी समन इलीगल नहीं होता, क्योंकि समन दिया गया है आपको अपीयर होने के लिए कि यू हैव टू अपीयर, और जो क्वेश्चन आपको आईओ पूछेगा जिसने समन इश्यू किया उसका आपको जवाब देना है. यू हैव टू डिपोज. तो शेड्यूल नहीं भी है. मान लीजिए पहले समन में एक शेड्यूल गया, आपने वो डॉक्यूमेंट सारे भेज दिए लेकिन आप अपीयर नहीं हुए, ठीक है, तो दूसरे समन में उस शेड्यूल को दोबारा तो नहीं लिखा जाएगा. तो ये कहना कि मुझे नहीं पता शेड्यूल था या नहीं था, क्योंकि मैं जी मेरी नॉलेज
ये तो अब एजेंसी बताएगी कोर्ट में. और
लेकिन यदि शेड्यूल नहीं भी है तो सम्मन इलीगल
नहीं होता. I think Ashwini Dubey was mentioning, the lawyer on the panel, that there is actually no provision under which a summon can be declared illegal unless there was some factual error or an error of a mistake under which it was issued.
Or the officer who issued the summon, who is not authorized to issue the summon.
Issue that summon. I get what you're saying.
Yes.
So I don't know where this legal argument has come from. At that time, it was said that Hemant Soren had also used these arguments and Arvind Kejriwal could be taking a leaf out of his book. Now, Hemant Soren, we know what has happened. Eventually, he has had to comply and eventually he has been taken into custody as well. Yeah. Perhaps it is an arrest that the Aam Aadmi Party and Arvind Kejriwal are fearing. They do say publicly that we are going to be arrested and that is what the BJP is looking for. I do request my guests to just stay on with me for 2 minutes because I'm getting another update which is in context to this case that we're talking about, which is the liquor scam case. Now, there is another setback to Aam Aadmi Party today. Jailed Aam Aadmi Party MP Sanjay Singh has not got any relief from Delhi High Court. The High Court has denied bail to Sanjay Singh in this matter, saying there is no ground for bail made out at this stage. I want to go across to Vandana ji very quickly. This is the political problem, Vandana, that courts are not giving you any relief despite the fact that the Aam Aadmi Party has been saying there is no case. There is not even a line of case. There is no evidence. There is nothing against our leaders, but no relief is coming from the courts.
Shivani, I'll tell you, because PMLA is the only act in India where getting a bail is almost impossible. Because PMLA, जो act है, is specifically this is for the narcotics and terrorism. So the act was like that, and taking advantage of this act, the BJP using their agencies they indulge all the opposition's leader in only PMLA. So because there is no case for the IPC, no case for CRPC. The only all the opposition's leaders are released with the PMLA, because getting a bail in the PMLA cases are almost impossible. So it is very clear that why all the opposition's leader are being released in only PMLA cases or
Okay.
investigated by
Anuja,
the
30
ED.
seconds to you as well. Sanjay Singh denied bail by the High Court as well.
I think again, when you were talking about the high courts, you just said, Shivani, it is all about the courts. So the courts know about the situations. Courts have seen the evidence. I am also a lawyer. When we put our contentions in front of the judge, they look into the evidence. They don't look at the face of who's the person who's standing. Is it a party of some politicians or not? Because in court, everybody is equal and equal rights are being given and equal towards the court.
Okay.
So you have to talk about it in the evidence in the court. Now, when I'm saying this, they are talking about that the PMLA. I don't think it is about the PMLA who cannot give the bail or not. It is the thing that the situation which is in front of you, the evidences, the prima facie, and they have also talked about during the agency, the probe agency has said that the Sanjay Singh created a special purpose vehicle to launder money. That is what the contention was being given in the court right now. And so, do you think this is a joke? No, this is not a joke.
I think the charges are very, very serious.
Yes, it is.
Running out of time, I think the charges are very, very serious. There will be both political and legal implications and accountability that has to be set. And fundamentally, given the political climate that we are in, it will have to be done via courts. We'll see what happens on February 17 or before that. I do thank all of our guests for joining us. Coming up after a very short break, Centre versus South over funds allocations intensifies. Karnataka leaders today, the entire cabinet was in Delhi to lay siege against the centre. We'll get you more in just a bit.